So, this week we are looking at pretrial procedures and specifically plea bargaining. As I've said in previous chapters, plea bargaining is about 95% of criminal cases. So, plea bargaining basically is the idea of coming to an agreement, the prosecution and the defense, where there could potentially be some leniency. In exchange for not going to trial. They are subject to judicial approval, and sometimes they're even given in cases where you need that individual as a witness against somebody else. The US today, very few cases are settled with jury trials. Why? Well, it saves time, money, and typically individuals get a better sentence if they plea out than trying to go all the way through trial. Different types of sentencing systems may affect plea bargaining. So if there's a mandatory minimum, if you're a habitual offender, like 3 strikes. And there's also sentencing guidelines. So if it says that you have to give a minimum 25 years to life in a murder trial, they can't plea lower than that sentencing guideline. Following the Civil War, plea bargains became increasingly common as a way, obviously, to save taxpayers time and money. And then it was just evolved into being the dominant way of resolving criminal cases. And it is fairly common in civil cases as well it's not called a plea bargain, but to make a determination or an agreement previous to going to trial. So plea bargains increase as a result of increasing professionalism between police and the criminal system. So having everybody work together efficiently and effectively allows us to get all the information available faster, so we're able to make determinations and allow plea bargains that would be fair and equitable to society. All plea bargain agreements have to be approved by the judge. We want to make sure they're fair. We want to make sure they follow the law. Most of the time they're going to agree because, again, they're cost effective and they're time efficient. But if they're not fair, or say the victim's family disagrees or has big issues with it, the judge can decline the plea bargain. Why should a defendant plea bargain? Well, if you're going to enter a guilty plea and you're in fact pleading guilty, then you would want to accept a lesser sentence. Or if there's substantial evidence against them, or there's a prejudice that potentially could cause them to be convicted to a longer, harsher sentence. Prosecutors are not obligated to offer or enter a plea bargain. They do have the advantage in resolving cases without a trial, and it is the easiest way for both defense attorneys as well as prosecutors to solve a case. Plea bargaining is a very powerful political tool as well. Think of, say, cases of child neglect or child endangerment or molestation. Obviously, those are cases that you don't want to necessarily plea out. Unfortunately, sometimes you do have to plea them out because maybe the witnesses aren't credible or aren't able to testify, or you just don't have enough evidence against the individual. But could somebody running for judicial office use that against their opponent? Absolutely. In some cases, plea bargains have been struck while a case is in progress, or even while a jury is deliberating. Maybe the trial didn't go as well as the individual had thought it was, and so then they agree to take a plea bargain. It cannot be coerced. Some argue that it invalidates due process. Oftentimes, defendants will feel pushed or coerced into a plea bargain so that their attorneys, quote unquote, don't have to do as much work. If the judge believes that it's coerced or that it is entered into against the interest of the client, then they can override it and decline it. But they need to make that determination. And then there's several cases. McCann v. Richardson. Merely alleging you were coerced is insufficient for overturning a conviction. And then North Carolina v. Alford, entering a plea agreement to avoid the death penalty is not coercive. For the sheer fact that you're avoiding the harshest punishment we have available doesn't necessarily mean that you were pushed into it. And then lastly, Brodenkircher versus Hayes, prosecution may use additional charges as leverage to obtain plea agreements. But those charges must have sufficient probable cause, and they have to be contemplating charging the individual with those charges. They can't just arbitrarily bring something out of the blue. There are 4 types of plea bargains. There's implicit, there's charge reduction, judicial, and then sentence recommendation. So we'll go through all 4 of them. Implicit bargaining is an agreement of a guilty plea for a specific offense, which carries a conventional punishment. So if the going rate is usually less than the maximum sentence. So if you plea out to a robbery charge that normally is 25 to life and you take 15 years, it's going to be less than obviously you would have been given had you gone to trial. Charge reduction is basically making an offer to minimize the number and seriousness of the charges. So maybe you were in an accident or some sort of altercation where the individual was killed. And initially you were charged with second-degree murder, but then they drop it down to manslaughter for a plea bargain, which obviously is going to carry a lot less time and a lot less serious charges. And then judicial plea occurs when a judge makes an offer of sentence to the defendant in open court for a plea bargain. This is usually with petty offenses like petty theft or some minimal drug charges. And lastly, sentence recommendation is when the prosecutor proposes a specific sentence in exchange for a guilty plea. Judges must approve all these in all jurisdictions. There is a huge gender disparity in plea bargaining. Gender disparity studies indicate that females with no prior records are more likely than males to receive charge reductions and less severe sentences. Typically, hypothesis proposes that women are treated with chivalry in criminal proceedings, but only when their charges are consistent with stereotypes of female offenders. Selective chivalry suggests that the decision makers extend chivalry disproportionately towards white females. So what does that mean? Well, it means that oftentimes minority males are going to get a lot harsher sentences than, say, females, and specifically white females, just by the data that we've seen in plea bargaining. What are the arguments for it? Well, it's going to reduce the uncertainties. It's going to make your case process quite fast. It's going to result in a large number of convictions, which could potentially be good or bad, but it's probably also going to reduce and soften the sentencing as well as the costs for sentencing, which is going to save, again, taxpayers sufficient amounts of money. What are the arguments against? Well, obviously, there are some big ones. The defendants may be ignorant of the law. They may be pushed into this, and it could circumvent habitual offender statutes and mandatory penalties. So it could actually let, quote unquote, the bad guys back out a lot faster than society would like to see them out. Sentence reductions for the underdeserving or concealing heinous aspects of the crime. So, the public's not going to afford or be afforded the right to see what happened in that crime because it pled out. Questions raised about factors related to plea bargaining include, do extra legal factors play a role in who will receive the plea? Well, it is, county by county, state by state. We all have different guidelines, and we do have mandatory minimums, but you may commit a crime in Merced County, and you're going to be charged differently or pled differently than in Stanislaus County, depending on the prosecutor you get, depending on the legal counsel you have, and it is going to change and make disparities in plea bargaining. And there are bans in various jurisdictions, notably Alaska, that banned plea bargains in 1975. It was important to note, though, that although they were banned, they did not disappear. They did kind of change the way they worded it, and they began allowing sentence bargaining. Federal Rules of Criminal Procedure in Title 18 of the U.S. Code outline all the protocols following offender processing from arrest to conviction. Items 11, 12, 13, and 14 have great significance to the defendants, and it determines whether the guilty plea entered by the defendant was actually, in fact, voluntary. You want to look at that, as well as looking at federal courts, because state courts and federal courts are run differently, and looking at the negotiating parameters of the prosecutors and defense counsels in federal court versus state court. And then there's PSI reports. These are filed by probation and parole, containing background information, and these can be included in the case as well. And these could be used to influence the sentence imposed by the judge. So that's chapter 8, guys.